Good morning, Attorney Soriano and UT classmates. I am Elvin Cavillon and my groupmates are Mr. Charlie Abejo, Mr. Rans Daba Achacoso, Mr. Emil Artajo, Mr. Jared Hans Barkelia, Miss Marjorie Bungalan, Mr. Michael Siliona, Miss Gail Curo, and Miss Queenie Digamon. And we are the Group 1 of Section Law 1T. Today, we are going to discuss 3 chapters in the book. Thank you, and the reporter may start now.
Good afternoon, everyone. We are the Group 1 and today we are going to discuss the Chapter 3 entitled Form of Contract.
Meaning of forms of contracts. The form of a contract refers to the manner in which a contract is executed or manifested. The contract may be oral or in writing, or partly oral and partly writing. If in writing, it may be in a public or private instrument. When contract is considered in written form, it is generally recognized that to be a written contract, all its terms must be in writing. So, a contract partly in writing and partly oral is, in legal effect, an oral contract.
Classification of contracts according to forms. The classification of contracts according to form are informal or common contracts and formal or solemn contract. Informal or common contracts, which may be entered into in whatever form provided all the essential requisites for their validity are present. Formal or solemn contract, which is required by law for its efficacy to be in a certain specified form. Rules regarding form of contracts. So the first rule is general rule. This means that contracts that are binding and therefore enforceable reciprocally by the contracting parties, whatever may be the form in which the contract has been entered into, provided all the 3 essential requisites, which are the consent, object, and cause, for their validity are present. An example of general rule is when E left a note in the store, G offering 1,000 pesos for a table G is selling. The following day, G called E by phone accepting the offer of E, who promised to pay the next day. The note and the other oral acceptance constitute a legally enforceable contract, and both E and G are fully bound. And the second rule is the exceptions. These rules is required in the following cases. A. When the law requires that a contract be in some form to be valid. B. When the law requires that a contract be in some form to be enforceable or proved in a certain way. Or C. When the law requires that a contract be in some form to be convenience of the parties or for the purpose of affecting third person.
Forms of validity of contract. There are rare cases when the law requires the contract be in a certain form of validity of the contract. And these are the examples form of validity of contracts. First, donation of real property. It must be in a public instrument. Second, donation of personal property, the value which exceeds 5,000 pesos. The donation and acceptance must be in writing. Third, sale of land through an agent. The authority of the agent must be in writing, otherwise the sale is void. Fourth, stipulation to pay interest. It must be in writing, otherwise no interest is due. And lastly, contract of partnership. If immovable are contributed, it must be in a public instrument, to which shall be attached a signed inventory of the immovable property and contributed.
Form for enforceability of contract. According to Article 1403, in the cases of contracts covered by the Statute of Frauds, the law requires that they be in writing subscribed by the party charged or by his agent. If the contract is not in writing, the contract is valid, assuming all the essential elements are present. But upon the objection of the party, it cannot be proved and therefore it cannot be enforced unless it is ratified. Next is form for the convenience of the parties. In certain cases, a certain form, for example, is the public instrument, is required for the convenience of the parties in order that the contract may be registered in the proper registry to make effective. As against third persons, the right acquired under such contract. Non-compliance with required form would not adversely affect the validity nor enforceability of the contract between the parties themselves. As between the parties, the form is not required because they are permitted by law to compel the other to follow the proper form. and this right may be exercised concurrently with the action to enforce the contract. It is essential, however, before a party may be compelled to execute the required form, that the contract be both valid and enforceable. So these are the examples. Example number 1. G donated real property to E in a private instrument. The donation is void because a donation of real property is required to be in a public instrument to be valid. For this example, the Article 1357 does not apply. For example number 2, if the contract of sale is in private writing, then it is valid and binding, although it is still executory, but only as between the parties and not as against third persons, without notice until the sale is registered in the Registry of Property. For example, if E is the vendee, he has right to compel G to put the contract in public instrument so that it can be registered to affect third persons, notwithstanding the absence of express agreement between them to that effect. Inasmuch as the contract is both valid and enforceable, the execution of public instrument becomes a mere matter of form and convenience.
Contracts which must appear in a public document. The contracts covered by this article are valid and enforceable, though not embodied in a public document or instrument or in writing. The public document is required only for the convenience and greater protection of the parties, and registration is needed only to make the contract effective as against third persons. In other words, the law does not require the performance of specific acts or contracts in a public instrument in order to validate the act of contract, but only to ensure its efficacy so that, once the existence of the act or contract has been admitted or established, the party bound may be compelled to execute the document. These are the examples for contracts which must appear in a public document. For the creation, etc., of real rights over immovable property. Example: as security for his debt, R mortgaged his land to E. This mortgage must appear in a public document. The extinguishment of the mortgage, upon payment of the debt by R, must likewise appear in a public document. Sales of real property or interest therein are governed by the Statute of Frauds. Next, for the cession or renunciation of hereditary rights or of those of conjugal partnership of gains. First example: S and D are the heirs of F, their deceased father. S, being financially stable, renounces his share in his inheritance. This renunciation must appear in a public instrument. Second example is the power to administer property. P is leaving for the United States to study for 2 years. He appoints A to manage his property. In this case, the authority of A to administer the property of P must appear in a public document. And last example, in the cession of actions or rights. R mortgaged his land to E to secure of the payment of a debt. This mortgage appears in a public document. The cession by E of his right as mortgagee to T must also be in a public document.
Good afternoon, everyone. Now we will discuss Chapter 4, which is the reformation of instruments. Let's identify first the meaning of reformation. Reformation is that remedy by means of which a written instrument is amended or rectified so as to express or conform to the real agreement or intention of the parties when by reason of mistake, fraud, inequitable conduct, or accident, the instrument fails to express such agreement or intention. Reason for reformation. Equity orders the reformation of an instrument in order that the intention of the contracting parties may be expressed. There are 5 requisites of reformation. First is there is a meeting of the mind of the parties to the contract. Second, the written instrument does not express the true agreement or intention of the parties. Third, the failure to express that true intention is due to mistake, fraud, inequitable conduct, or accident. Fourth, the facts upon which relief by way of reformation of the instrument is sought are put in issue by the pleadings. And lastly, there is clear and convincing evidence of the mistake, fraud, inequitable conduct, or accident. Reformation distinguished from annulment. According to Article 1359, in Reformation, there has been a meeting of the minds of the parties. Hence, a contract exists but the written instrument purporting to embody the contract does not express the true intention of the parties by reason of mistake, fraud, inequitable conduct, or accident. Furthermore, in Article 1390, in annulment, there has been no meeting of the minds, the consent of one of the parties being vitiated by mistake.
J sold his land to K. It was agreed that the sale will include all the improvements. However, the contract as signed by the parties states that the land is being sold, excluding the improvements thereon. In this case, the remedy is reformation because there has been a meeting of the minds. If J was selling his land excluding the improvements and K was buying the land including the improvements, then there has been no meeting of the minds and the remedy, therefore, is annulment. Reformation cannot be the remedy because, either way, it would not make the instrument express the real intention of both parties.
Principles of the General Law on Reformation. In case of conflict between the provisions of the new Civil Code and the principles of the General Law on Reformation, the former prevail. The latter will have only suppletory effect.
Under Reformation, mutual mistake is a mistake of fact that is common to both parties of the instrument which causes the failure of the instrument to express their intention. Number 1, the mistake must be fact, for if it is one law, the remedy is annulment. Number 2, such mistake must provide by clear and convincing evidence. Number 3, the mistake must be mutual, that is common to both parties to the instrument. And lastly, the mistake must cause the failure of the instrument to express their true intention.
Dan and Odapep signed a contract on the selling of his 2 cars. Odapep told Dan to sell the Y car first so that there will be more attention to the second car, but unfortunately Dan closed a deal and sold the second car, which is black, and forgets about the agreement. Therefore the instrument mistake is of law. The remedy is annulment. If one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show there.
Mistake on one side, fraud or inequitable conduct on the other. Under Article 1362, the right to ask for reformation is granted only to the party who was mistaken in good faith. Here the mistake is not mutual. Concealment of mistake by other party. The remedy of the reformation may be availed of only by the party who acted in good faith. The concealment of the mistake by the other party constitutes fraud. Ignorance on the part of third person. Under the above article, neither party is responsible for the mistake. Hence, either the party may ask for reformation.
Under mortgage or pledge stated as a sale, the reformation of the instrument is proper because otherwise the true intention of the parties would be frustrated. After all, such true intention must prevail, for the contract must be complied with in good faith.
Example, when person D and C engaged into contract where they agreed pertaining to a mortgage of a real property that D will acquire, however it was indicated in the instrument that it was already sold absolutely. And so, reformation of the instrument is proper since the parties has mutual intentions, so that there will be no conflict on the said contract.
In cases when reformation is not allowed, the first case is when there is simple donations inter vivos where no condition is imposed, because donation is an act of liberality whereby a person disposes gratuitously of a thing or right in favor of another who accepts it. And inter vivos, a Latin phrase, is where the donor intends that the donation shall take effect during his lifetime. The second case are wills. A will is an act whereby a person is permitted with the formalities prescribed by law to control to a certain degree the disposition of his estate to take effect after his death. The third case where reformation is not allowed is where the real agreement is void. If the real agreement is void, there is nothing to reform. Reformation would be useless because the real agreement is being void in the first place and thereby unenforceable. And the last one is where one party has brought an action to enforce the instrument. Here, when a party brings an action to enforce the contract, he admits its validity and that it expresses the true intention of the parties. Thus, the bringing of the action is inconsistent with reformation. So under reformation, the following parties are entitled to it. First, it is either of the parties if the mistake is mutual, and this was provided under Articles 1361, 1364, and 1365. Second is in all other cases, particularly of the injured party, which was provided under Articles 1362, 1363, 1364, and 1365. And lastly are the heirs or successors in interest in place of the party that is entitled. In procedure for reformation, here, as a general rule, all persons interested in the subject matter of a legal action, whether it is a legal or an equitable interest, should made parties in suits to reform written instruments, so that the court may settle all of their rights at once and thus prevent the need of multiple suits.
For example, in an action to reform a deed of sale of a vehicle, the parties claiming an interest in the property, who are Pablo and Maria, are conveyed by the instrument sought to be reformed, and the parties necessary to the action are whose interests that will be affected by the reformation of the instrument.
Hello, good morning again. So now we will going to discuss the chapter 5, which is the interpretation of contracts. So first, what is the meaning of the interpretation of contracts? So the interpretation of a contract, according to the book, it is the determination of the meaning of terms or words used by the parties in the written contract. So it is like a process of ascertaining the intention of the parties from the written words contained in the contract. Literal meaning control when language clear. Contracts, which are private laws of the contracting parties, should be fulfilled according to the literal sense of their stipulations. So if the terms of the contracts are clear and unequivocal, so the parties are bound by such terms. In this case, the question is not what existed in the minds of the parties, but what intention is expressed in the language used. So for easier to understand, I will give you some examples.
A contract was executed between G and B. The contract recites that it is a sale of parcel of land belonging to G for 100,000 pesos. In the contract, G is described as the vendor, and B, the vendee. The terms of the contract are clear, and it does not appear from the circumstances that the intention of the parties is contrary to the literal meaning of the said terms. Therefore, the contract should be considered a contract of sale. No interpretation should be given which would alter or change the plain meaning of the wording thereof, it not being lawful to make a new contract between the parties.
One of the conditions specified in a fire insurance policy is that the insured must give notice of the existence of other policies against fire upon the property insured, otherwise, the policy shall be null and void. This condition and the property was destroyed by fire. Though the contract may be rather onerous, the insured cannot recover. As its terms are clear and unambiguous, they must be taken in their plain and ordinary sense. Obligations arising from contracts have force of law between contracting parties. Article 1159.
Evident intention of parties prevails over terms of contract. So it is a situation where the words and clauses of a written contract are in conflict with the manifest intention of the parties. So the latter shall prevail over the former. It is like a cardinal rule in the interpretation of contracts that the intention of contracting parties should always prevail because their will has the force of law between them. So for easier to comprehend or to understand, I will provide some examples.
W sold to Z a parcel of agricultural land. It is not disputed that the reasonable value of the land is 50,000 pesos. However, the contract of sale states that the purchase price is 500,000 pesos. In this case, as the amount of 500,000 pesos appears to be contrary to the evident intention of the parties, the latter shall prevail.
R entered a contract called Contract of Lease with E, whereby R leased his car to E. It is stipulated that E shall pay 100,000 pesos upon the signing of the contract, and 5,000 pesos by way of rental on or before the 5th day of every month. And at the end of 1 year, E would become the absolute owner of the car. The contract fixed the value of the car to be 160,000 pesos. There can hardly be any question that the contract is not a lease of the car, but a sale on installments. The so-called rent must necessarily be regarded as payment of the price in installments, inasmuch as the due payment of the agreed amount results, by the terms of the bargain, in the transfer of title to E, the alleged lessee.
Parties to a contract have given a practical constructions to the terms. Although Article 1371 speaks of acts contemporaneous and subsequent to the celebration of the contract, antecedent circumstances under which it was may be also considered. A and B entered into a contract entitled Contract of Lease. Although the contract refers to A as lessor and to B as lease, it states that the possession and ownership of the land are transferred to B. The title to the land was given by A to B, who registered the land in his name. Before the date of the contract, B wrote a letter to A. This is for her to offer A to buy the land. Special intent prevails over a general intent. As a rule, wherein a contract there are general and special provisions covering the same subject matter are inconsistent, the latter shall be paramount to and control over the former when the two cannot stand together. A sold her house, including all the furniture therein. The term all should not be understood to include A's refrigerator, which is distinct and different from furniture. Neither should it be interpreted to include chairs borrowed by A from B for the reason that they do not belong to A. A sold parcel of the land to B. In the deed of sale, the description stated a greater extension than the actual area of the lands sold, thereby including a piece of land belonging to C. This piece of land cannot be among the subject matter of the sale, simply because it was included in the description. A mortgaged his land to secure the debt of B to C, without expressly assuming personal liability for the debt. In case there is a deficiency remaining after the mortgage is foreclosed, A cannot be compelled to pay the same.
Interpretation of stipulation with several meanings. When an agreement is susceptible of several meanings, one of which would render it effectual, it should be given in that kind of interpretation. Thus, if one interpretation makes a contract valid and the other makes it illegal, the former interpretation is one which is warranted by the rule stated in Article 1373. So, we will provide example of this topic.
E sold her parcel of land to J. Now E has two lands. One owned by her absolutely, and another land of which she is a co-owner with C. C did not give his consent to the sale. The sale should refer to the and owned by her alone, as this would make the contract effectual.
Interpretation of various stipulations of a contract. A contract must be interpreted as a whole, and the intention of the parties is to be gathered from the entire instrument and not from particular words, phrases, or clauses. So, having in mind it is in the intention of the parties and the purpose to be achieved, consistent with their contemporaneous and subsequent acts, referred to Article 1371.
R leased his house to E. In the contract, it was stated that he should not sublease the house without the written consent of R. Another stipulation therein contained stated that he should pay 1,000 pesos as additional rent a month should he violate this condition. E subleased the house without the consent of R. Has R the right to eject E? No, in the light of the clause stating the penalty for the violation of the condition.
Interpretation of words with different significations. So the description for interpretation of words with different significations is a word is susceptible of two or more meanings, and it is to be understood in that sense which is most in keeping with nature, and or if the object of the contract in line with the cardinal rule that the intention of parties must prevail. Refer to Article 1370.
R leased to E a roof for the purpose of erecting an advertising sign. The contract provides for the termination of the lease by E if a building should be constructed on an adjoining property of such height as to obscure the view of E's sign. There was erected on the roof of an adjoining building a sign which obstructed the view of E's sign. In this case, the term building as the term is used in the contract may be interpreted to include the obstructing sign, having in mind the nature and object of the contract.
And lastly, resort to usage or custom as aid in interpretation. So the description for this is usage or custom of the place where the contract was agreed or both parties have agreed may receive to explain what is doubtful or ambiguous in the contract, or that both parties entered into their contract with reference to usage or custom. However, it is necessary to prove the existence of the usage or custom like any other fact, according to the rules of evidence, and they must have the burden of proof on both parties alleging it. But usage or custom is not admissible to supersede or vary the plain terms of the contract.
X rendered services to Y, but the contract did not provide for the amount of compensation to be paid. In this case, the amount must be determined by the rate customarily paid in the place where the services were rendered.
Interpretation of obscure words. A written agreement should, in case of a doubt or ambiguity, be taken contra proferentum. It should be interpreted strictly against the party who has drawn it, or be given an interpretation which will be favorable to the other, who upon the faith of which has incurred an obligation. That means it is fair, logical, and sensible not to favor the one who caused the ambiguity in the contract because he should not benefit from it. Therefore, drafters of contract must be very careful and cautious in the choice of words or term they're going to use. The term should be clear and should leave no room for doubt regarding the true intention of the parties. Rules in case doubts are impossible to settle. When, despite the application of the preceding rules, Articles 1370 to 1377, certain doubts still exist, such doubts shall be resolved in accordance with the supplementary rules stated in the present article. First, gratuitous contract. If the doubts refer to incidental circumstances of a gratuitous contract, such interpretation should be made which would result in the least transmission of rights and interests.
Gratuitous contract.
R gave his car to E.
It is not clear whether the contract is a donation or accommodatum.
the contract should be presumed as a mere commoditum because it would transmit lesser rights than a donation since R retains his ownership of the car. Onerous contract. If the contract in question is onerous, the doubt should be resolved in favor of the greatest reciprocity of interest.
Onerous contract. D. Borrowed from C 5,000 pesos at 18% interest. It cannot be determined from the terms of the contract whether the loan is payable in 6 months or in 1 year.
It must be assumed that the period agreed upon is 1 year, which results in a greater reciprocity of interest, since D can use the money for 1 year, and C, on the other hand, can earn interest due for 1 year instead of only 6 months. Principal object of contract. This means that if the doubt refers to the principal object of the contract and such doubt cannot be resolved, thereby leaving the intention of the parties unknown, the contract shall be null and void.
Principal object of contract. S. Sold his land to B. S. has many lands. It cannot be determined which land was intended by the parties to be subject of the sale. Therefore, the contract shall be null and void, and it is as if the parties have not entered into any contract at all.
Principles of interpretation in the rules of court applicable. The rules in the rules of court on the interpretation of documents are now contained in Rule 130, Sections 8 to 17 thereof. First, for partly written contract, if there is a conflict between written and printed portions of a policy, the written portion prevails. Section 13, Rule 130 of the Rules of Court provides that when an instrument consists partly of written words and partly of printed form, and two are inconsistent, the former controls the latter. Next, for language in the place of execution, the language of the writing is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intended otherwise.
That's all for today. Thank you for listening. And again, we are the Group 1 of Law 1Z. Thank you and God bless.